Good evening. Thanks very much for your time. Some serious allegations really being leveled by the SIU here. What do your clients have to say for themselves?
Good evening, Vuyo, to you and your viewers. Well, firstly, I think we need to characterize the nature of the so-called irregularities to put context to it. It has to do with a recommendation through a normal supply chain procurement process of the SABC, which recommended to the board the appointment of a security company to take care of the security needs of what is a national key point. In the run-up to this recommendation, the interim chairperson of the board received a whistleblower complaint, basically suggesting some untoward conduct on the part of internal staff within the SABC who were alleged to be colluding with one of the bidders, the very recommended bidder Mjayeli. So that obviously raised red flags. The allegations are really about whether they have followed the letter of the law insofar as that procurement process is concerned in the following respects. When you as a public entity choose a bidder other than the one that's ranked first, there are criteria that you must satisfy in terms of the Preferential Procurement Framework Act in choosing a bidder other than the one that scored the highest score. That is the nature of the allegations that are being investigated. Did they follow the letter of the law in choosing number 2 instead of number 1?
Now, I mean, if red flags were raised and with that the possibility of untoward conduct, as you called it, one would have thought that the board would have been a lot more circumspect in how they dealt with this matter and not simply approve a recommendation. Or do we know what actually happened?
Well, the context is this, in this respect, Vuyo. This security tender had been cancelled twice before, and the incumbent's contract had therefore been extended also twice before. What was put before the board was a deadline of 31 July 2017, would have been the end of the current contract, and they were advised that under the PFMA, they would have difficulties with National Treasury if there was another extension of the incumbent's current contract. So there was that burning deadline looming. Secondly, because of the very whistleblowing allegations, they were very, very rigorous in interrogating what was put before them by a bid evaluation committee. So put differently, they had to seek the advice of the head of supply chain management to say to that particular person, look, we've got challenges here. The first challenge is the allegations of collusion between the number 1 recommended bidder and internal staff. But secondly, there was also concern around scores which had clearly been altered during the evaluation process. And they said, can we in these circumstances proceed and consider the other bidders and take a decision on who to award the contract to. And they also sought legal advice at that particular meeting. The head of legal referred them to Section 2 of the Act, which says they are more than entitled to deviate from the recommended highest scoring bidder, provided there's objective criteria to justify that. They then went into a debate about those objective criteria, and those ranged anything from the BE scoring of the company, its experience. It had previously done security work for the SABC, and there were many other considerations attendant upon them in arriving at the decision to award the contract.
With due respect, Mr. Malatji, I mean, I know of cases where the SABC was given legal advice and actually went on to lose in court. And it's a very supply chain management you're talking about, which you say, I mean, also advised the board, was, I mean, allegations were leveled against people who are part of the supply chain management that, you know, they conducted themselves improperly during the course of this particular bid. Would it not have been prudent for your clients to have perhaps spoken to or engaged Treasury, rather, even if it meant falling foul of the regulations, to ensure that they got it right?
Well, we remember that the challenge they were faced is that the current contract could not be extended any further. And that extension would have resulted in a definite irregularity. Now, what other option did they have? The other option they had, which they were advised by legal more than supply chain management, was that you are entitled to have a look at all the bids and choose any other bidder other than the successful bidder. And they did so. And I mean, things such as, for instance, the pricing difference was a minuscule 0.13%. You know, the one they chose did not have any allegations against them, and eliminating a potential risk of a bidder who already has allegations made against them was another consideration for them. So, and ultimately, they were advised that in choosing the second highest bidder, they are acting within the four corners of the law. And of course, yes, cases are fought in one view, sometimes rightly or wrongly so. But in this particular instance, we have ourselves reviewed those records of the SABC board meetings, and we've advised that they've acted within the four corners of the law. And I must add a last point, which is this. The process culminating in a board deliberation and decision is extremely rigorous, even at board level. So one of their subcommittees had taken the effort of perusing and analyzing all of those bids in order to ensure that when the board ultimately deliberates and decides on it, they can then defend their decision. And the SABC is indeed doing so. There is a pending court case by the unsuccessful bidder.
Mr. Malatji, thanks very much for your time.